Welcome everyone! I'm really excited for today's conversation. My guest is Clarissa Rodriguez. She's a partner at Harper Meyer LLP, a board-certified expert in international law, and a key member of the firm's Art and Entertainment Law Group. Clarissa spans commercial disputes, international arbitration, film and art market counsel, and helps high net worth cross-border clients make sense of art world complexity. Clarissa, thank you so much for being here.
Thank you for having me.
Now, you've built such an interesting cross-section of practice: art, international law, and dispute resolution. What is art law, and what originally drew you to that intersection? And when did you realize it could become a focused, scalable niche?
Wow, that's a big question to start with, but sure. Okay, so my path to art law was not traditional. It was truly accidental. Like most lawyers that came out of law school, when I came out of law school, practice was very, at least my mindset was very traditional. You went into litigation or you went into corporate, and within those niches, you developed your skill sets and you became what you became. My skill sets have always been litigation, arbitration, focus on international law, because I am in Miami, and Miami is what is the, let's say, unofficial capital of Latin America. It is a gateway of business between Europe, the United States, all of the Caribbean, all of LATAM, Brazil, everywhere. And so the focus has always been dispute resolution here in Miami with that cross-border context. Passion for art has always kind of existed, but not in a law context. So like most children in the 80s, I was raised on Blockbuster videotapes, and those included watching all of the Indiana Jones series. And I promptly decided that I wanted to be an archaeologist. And my father looked at me, and as a child, and I thought he'd be so proud, because I didn't want to be like a shark or a Barbie. I was actually picking a career. And he said, that's awesome. Archaeology's wonderful. It's truly fascinating. He's like, I just, one hiccup. And I said, okay. And he goes, you don't like to be outside. And I was like, touche. That's fair. That's fair. There will be no archaeology for me. And that career kind of got sidelined. But I do know, I guess I know now, in college, I couldn't help but take anthropology, archaeology, and art classes for fun. I ended up having a minor in those things only because they were naturally interesting and naturally called, right? And so the interest in the arts and the interest in anthropology, archaeology were just interests, things that I liked and things that I enjoyed. So jump to, I've been practicing in my career for 10 years or so, and I attend a conference, and the guest speaker gave a talk. The guest lecturer at this conference, his talk was about his experience in being involved in the restitution of Nazi looted art. And it was like a watershed moment. It was a bucket of water, like, wait, what? You can be Indiana Jones behind a desk. You can chase after the Nazis and do good things on paper. I'm down. I'm available. Let's do this. Like, what is this? I didn't even know that this existed. I had no clue. So I truly got in touch with the speaker. We became very good friends and colleagues. We not only became such good friends and colleagues, we developed a cross-border practice. He was in LA, I was in Miami. I became his Miami office, he became my LA office, and we started working together on some disputes. We did not, unfortunately, work on the Nazi restituted art disputes because those cases are it's so hard for the claimant and the victim to have a case. We met with so many Holocaust survivors and heirs, and we gave them an opportunity to share their story, their materials, and their background. And we did our very best to assist, but there are very few cases that can truly be proved. And so, but while I didn't get to work in that niche, which was just so fascinating, I did get involved in art law disputes, which dovetailed very, very organically into my disputes and international practice. And so that it all kind of came together at that time, listening to that speaker talk about all his work in litigation, all of his work in arbitration, all of the years that it took. And it was like light bulbs, right? That was the moment. And so I came back to Miami and said, okay, Miami doesn't have this. Miami has disputes, and Miami has art, and Miami has all these great things, but we don't have someone that could do an art law dispute. And so I at that time, I had opened up my own practice. My partner, Laura Reich, I looked at her and I said, this is something we should do. And she was like, absolutely, this is something we should do. And there it was. We were like, okay, let's do it. And so we just started letting our colleagues, our friends, folks in the art community, folks in our local community know that this is what we could do. And those cases just started showing up little by little. So now they do represent, a good part of our practice.
That's amazing.
For people who don't know art law, what exactly is art dispute?
Sure. So that's a great question. So within all types of law, and I don't mean to, I'll distill it. There is the there's the contractual part, the commercial part, and then there's the disputes part of every industry, if you will. And so when things go wrong with the transaction or with the event, that's when someone like me would step in. For art disputes are very different than art law. It's not about due diligence. It's not about provenance. It's not about acquisition or buying or selling or museums or nonprofit. It's about problems that arise in those arenas. So small example, you went to an art show, fell in love with a sculpture, paid for it on site. They're going to ship it to you. It shows up to your house broken. Or it never shows up. Or they don't want to sell it to you anymore. Or, anything like things like that can happen, right? I want to buy something. We enter into a contract and I never purchased it, but I kept it. Theft. Also, they're in Florida. Specifically, we have a statute for civil theft. I've had a case involving people fighting in the parking lot over a painting, and one person ripped it out of the other person's hand and drove off with it. And so, yeah, we called the police, but it was really a civil theft issue because there was a dispute over ownership of that piece. So there can be disputes over ownership. There can be disputes over inheritance. There can be disputes over value. Did you get sold a fake? I've had a lot of people get sold fakes, right? So they saw it on the internet and they thought it was real, and they buy it and they bring it and they get it authenticated and it's completely not real. All kinds of issues, all the problems, all the ways in which it could go wrong.
Wow.
That's what I'm available for. Yeah.
That's amazing. So what does a typical day look like for you?
Well,
Starting in the office.
So I will submit to you all that in the last 3 years, litigation has been just in general, litigation and disputes, I feel have significantly spiked. So I don't know if it's the temperature of the world. I don't know if it's just that people became more solvent after COVID. I don't know why it is what it is, but it is just a very, very, very high volume of work. There's just lots of disputes. So as a litigator, and I consider myself a litigator more than a trial lawyer, because while I go to trial, I litigate day in, day out. A typical day means getting up in the morning and avoiding my emails until I have dropped my kid off at school. Because I have learned that if I start answering emails in the kitchen, my kid will not make it to school on time, because I will stop what I'm doing and start answering emails. So the typical day is get the family and everybody out the door and check my emails for the first time around 7:45 in the morning. That's when we start. I start looking.
Send you any lengthy message in the morning then.
I'm sorry?
We'll make sure not to send you any messages.
No, please, God, not before. I mean, my clients do, right? Everyone's on WhatsApp and everyone, and we live in a world where there's 27,000 group chats. So somebody's still texting at 2 a.m. and somebody starts texting at 5 a.m. and you're everything's muted. But emails, I don't start looking at emails till about 7:45 in the morning, just to make sure there are no fires and things that just need to be handled. Hopefully the night before, my team and I have assessed if there are any hearings or any meetings first thing in the morning. Assuming none, I attempt, like everyone these days, to do a little bit of exercise before I come into the office. I roll into the office, and then there is a huge dynamic between communications with the clients and deliverables for the clients. Drafting what needs to be drafted for people's cases, but also being in contact with them. Unfortunately, in my world, they can't have both. You can't be in contact with me and get the draft that you're waiting on. You either lose contact with me and get your product, or we talk all day but you don't get your product. So it's that big interplay of finding a balance of answering my emails, talking to folks that I need to talk, but then giving myself an opportunity to draft what needs to be drafted. In my world, what needs to be drafted is generally lots and lots of pleadings, whether it's complaints and motions and responses to complaints and arbitration pleadings and all of that good stuff. We have a team. We meet frequently. We have a huge, you can't see it, but there's a huge whiteboard that covers the length of the wall where we've got running deadlines, who's handling what. And so during the week, you can expect a handful of hearings, maybe a deposition or two, certainly a bajillion Zoom calls and conference calls, and a ton of drafting and case deadlines. And because there's not enough time in the week, you can definitely expect on Saturdays that type of coming in, picking up things that just didn't get done, entering the time, working on a lot of admin stuff, attempting to just try to get a semblance of what we have a rule in our office, which is we try to keep items of that week in that week. We try not to let things bleed over. We endeavor. And so constantly just keeping up with the demand, which is pretty high.
We've been seeing actually when talking to our other guests that a major trend and a major shift that is happening in the industry for all in the law profession is an increase of cases and more information and everything. What other major shifts are you seeing in your industry right now?
I'm seeing a huge inflection point between the court not catching up to what AI can do in a pleading and attorneys using it, and we're at a big moment where I wonder if in the future we're going to have to certify all of our pleadings by saying that we either did not use AI, or we used AI and we verified, or we used AI and we didn't verify. Mm-hmm. Some sort of way to signal to the court what the attorneys are doing, because they're doing everything. There is a huge shift in our writing in state court. It's gotten sloppier and crappier because of AI. It's pretty low grade stuff because your output is only as good as your input. Mm-hmm. And to your point and what your guests have said, if the demands of the practice are rising, the timing, the need to produce immediately, like I was mentioning to you, do you want to talk or do you want the product? But you can't have both, right? And so trying to produce at a high rate is causing sloppiness because people are going so fast that they're feeding stuff into AI, getting the output and just slapping a sticker on it and moving forward. And I can, in our dispute group, we can 117% smell when it's been generated versus when it's human. Like we're almost like we should be testers. Like it's uncanny because you can tell when it's a human who did some slap ass work, and you can tell when it's the chatbot that produced something. And I don't know if the courts are also, but I have to think so. That the courts are starting to see it. They're definitely sanctioning attorneys more and more for it. Because it's again, the slapassery of what that chatbot produces is so crazy that I think we're at a really big inflection point regarding what is going to be expected of us as officers of the court in front of arbitration tribunals, in front of judges, in front of panels, to represent what we actually produced for our clients.
It's always like one thing to use AI as a tool, another to just totally ask you right and submit it without even reviewing or without any human input, without putting the human into the loop.
Yeah, there is something again, and I don't begrudge my colleagues because I understand the pressure. I would be lying to you if I told you that, my partner Laura and I have noticed that even our own writing is suffering because we don't have time. What is that Mark Twain letter that says, I would have written you a shorter letter, but I didn't have the time?
Yeah.
right? Like
Yeah.
I recognize I'm also constrained, and I'm rushing to put something together. And so I don't begrudge them for using it, but there is a certain level that like the output should be helping to make your product better, not be your product.
Absolutely.
Yeah. We talked with a pretty senior attorney who is leveraging AI in his firm. He was saying how he does use it as a tool, and his pie chart is shifting from doing a lot of administrative work or the writing of the basics to reviewing human and to improving the language model and all that. And he's very concerned for fresh law school students who do not have the experience to smell what is wrong, to simply rely on the generic AI, not even specifically proprietary information trained AI, but like the generic AI to spit something out, put their name on it and submit it.
Sure. The experience is what lets me know what's good and what's garbage, right? How do when I was a young girl, my grandmother was forced teaching me how to iron, and I was like, I absolutely do not want to know how to do this. And she's like, I know you don't. And I'm like, but I don't intend to iron in the future. She's like, I know you don't. She's like, you're going to pay someone to do this, but you want to make sure they're doing a good job. So you better learn how to do it yourself, right? And so I feel like, how in the world does anybody know that what they have asked the bot to produce and what it produced is good? Because like I said, the product's not there yet. It will be. Sure. 100%. We're 100%. We're getting to that, but we're not there yet, not by leaps and bounds. And I can tell when I've put in, I can tell, my partner Laura and I, we constantly grade the product, C product, B minus, D, whatever it is, because we know we've been practicing for a bajillion years and know what's good and what's not. A law student with no frame of reference would never know. That's right. That is a huge concern. That is a huge concern.
How have you seen this impact your own business or growth strategy?
So it has impacted us in the sense that 2 years ago, when in law, there's two main search engines that people use that are closed circuited, Westlaw and Lexis. And so we noticed that they were starting to introduce AI features, and we immediately signed on board because we figured that every firm is going to end up having to use them. And if you're not using it, you're losing, because there are so many nice bells and whistles that make the product better. Again, if you know how to use it correctly and you know how to harness what you have. And so we have been using the tools that help us to site check better, to quote check better, to find better law, or to research. We've been really testing the engine when it comes to researching super esoteric and difficult things, topics that would normally take 2, 3, 4, 5, 6, 7, 8 hours to research. We've been trying to use that to see if it helps us speed up the process. And so that's been, so we have the closed AI systems, we have the open AI systems, we have all that stuff to kind of back check us, spot check us, help us make our product, better, for sure. And if people aren't doing that, then they're losing. They're already falling behind.
Yes. So you were talking about the difficulty of your cases. Your cases often involve multiple jurisdictions, complex documentation, and high-value assets. What are the biggest bottlenecks you or your team face in managing that volume of coordination and information flow day to day?
Sure. And so the biggest challenge is always managing the client's expectations. They are already in a dispute, which means they're already in distress. Something has already gone terribly wrong. And so it is not helpful to continue showing them obstacles, but you have to manage their expectations. You have to set out, first of all, find out what are the goals. What is it that we're working for? Why are we doing all of this? Why are we moving as fast as we're moving, as hard as we're moving? Why are we going where we're going? In what jurisdictions, and what do we need? That's a hard thing to manage. Second thing is, when we finally do determine what jurisdiction we need to do, what all these things, is explaining to them why they can't or cannot get or move in the way that they want, in the space that they want. And then the rest of it, ironically, is easier, because the rest of it is pretty spelled out. Your paths, your litigations, your arbitrations, your processes are It's the process. The process is just a matter of learning the process and knowing what you have to do and reading the rules. That's key. Being a rule maven is key. Reading the rules, getting your deadlines right. But it's the logistics and the management that are truly, truly the most difficult things. People absorbing the cost, how long it's going to take, how much is expected of them, and the fact that as a law professional, you cannot give them guarantees of success. You're just not allowed to guarantee it, which is really, really hard because they're counting on this to be, they're counting on it, right? They're counting on success that you can't tell them to count. I mean, you're going to do your very best, but you can't control a judge and you can't control a jury and you can't control what the other side is going to do. So the hurdles are truly, in my opinion, not legal. They're the soft skills. They are the client management, case management, logistical management, just time management. Those to me represent the hardest challenges, not the type of issues presented, not the level of work necessary, not the fact that it would be across different jurisdictions or with dealing with different teams. That part seems to work itself out pretty organically. It's the other stuff that seems to me, from my perspective, the challenging for the group.
Yeah. From other lawyers who will talk to the communication part with the client, like you mentioned before, there are the two pieces that's a trade-off. You can't write, produce while calling, but like you also mentioned, they are in distress and they need that assurance. So that
Correct.
managing that communication part, the assurance part, like you said, the soft skill of the assurance, but also communicating that it's not a guarantee.
Correct.
While you do all the work, while you do your job.
Correct. I had a Zoom call that I did in my car yesterday after I had left court that I did in the parking garage for 47 minutes because we were on the call. And I kept on saying I was going to send it to them as soon as I got upstairs. There were 12 people on the call. They each needed to talk. They each needed to say, was it 47 minutes in the garage? I'd already been driving for 15 from the courthouse. So 15 from when I started, 47 minutes in the parking garage. And then I needed to come up and they were desperately waiting for that email that I hadn't been able to draft because I was in the car, because I was talking to them. And so, yes. So that call finished. I got up. So let me see. I left court yesterday at 10, let's say 25. I got upstairs to the office after the call and everything, let's say somewhere around 12:25. And I didn't get them the email till much later in the afternoon. And like you said, they're going, but clients need to be reassured. They need to be heard. They need to be validated. And they need things explained to them, and sometimes explained to them every single time like it's the first time. I have a case that's been going on for 5 years. 5 years. Every single time I talk to the client, I swear to you guys, like clockwork, my partner Laura laughs. He literally says, I don't know why I'm being sued. We start every call. That same way. So it's like Groundhog's Day. Like we literally start every day. And so that to me represent the challenges of the job. Ironically, the clients, it's not the craft. To me.
Yeah. I mean, no, it's really common that both from like legal assistant perspective and also a partner, like an entrepreneur, they have to think about the firm's perspective. They really can identify lawyer jobs as really two parts. There's that human creative part. Every case is different because really every case is different. But then there's that repetitive part, like the way you start your call every time, and it's just a standard answer and all that.
Yes.
What areas of that workflow do you feel like are like more human, like you wish you spend more time, it really needs what you're trained for to do, and what part of it that's more administratively heavy and repetitive?
So I am very lucky that the 97% of my practice requires my brain. So everything that I do all day requires one really, really important thing. And I can tell you exactly what it is because I just finished lecturing my mother about this the other day. My mother likes to call in the middle of the workday. I have, on accident, picked up that call thinking it must be important because it's the middle of the day and I'm at work, so she must need something. She'll ask me something, or she'll tell me something like, did you see that Serena Williams received an award from the Queen of Spain. Did you see what the Queen of Spain was wearing? I'm watching it on CNN. That was neither a question, nor is it urgent by any means. Can we discuss this later? Thank you. But I had a call with her and I said, Mom, you cannot call me anymore during the day unless it's an emergency. And I said, but let me tell you why. I get paid to do one really important thing, for my judgment. That's all I'm being paid for. I make a judgment call. For me to make a judgment call, I need to be able to think. And for me to be able to think, I can't be interrupted. So all day, every day, I'm being asked to make a decision. I judge. I make a judgment call, how we're going to run the case, what causes of action we're going to bring, where we're going to file the case, who are we going to file it against, what actions are we going to bring, what evidence do we have, what evidence do we need, what evidence do we want, what am I going to tell the client, what do I answer if they ask this, what do I answer if they ask that, what do I suggest to them that we should do, or enforce on them that I tell them that we're going to do. I make judgment calls every single day, all day, that determine where the case is going to go, what we're going to do, how we're going to do it, who's going to do it, when it's going to get done by, such that I need concentration, right? I need to be able to think because that's what I'm being paid for. The administrative stuff at the end is de minimis in my particular practice area. My biggest administrative thing is entering my time and collecting on my time when my bills go out, right? Like making sure that people pay. But short of that, my job is very heavily reliant on my thought. What do I think? What do I think? When a client emails me, how am I going to answer this? Why am I going to answer it this way? Keep it long, keep it short. We had a situation the other day that I used as a learning tool for my team. We had a client the other day who sent us a contract that was in English and Spanish with a couple provisions in Spanish that were dispute resolution that my partner wanted me to review and wanted me to opine on and tell them what I thought. I read the contract and I was like, holy crap, this is garbage. This is like complete and utter trash. So I was asked to opine on certain sections. So I wrote my certain sections and I wrote, like, this is not functional. This is poorly written. This does not accomplish that. And it was very like to the point, to the client, what they needed. They forwarded it to the other side.
Oh.
As is, raw, unadulterated. Basically, my attorney thinks your contract is shit.
Oh.
Here's what she thinks. So, of course, the other side wrote back super defensively, as they should, attempt, and it was just this little bit of back and forth. And I was just like, okay. So then, note to self. Then one of my other partners had a client who has a huge issue, who needed an assessment about whether or not he was likely going to be sued. And he had 3 direct questions. And I answered, yes, he's likely to be sued. Here's why, blah, 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 blah. He took my answer and he used it to see if other attorneys in other firms would answer the same way. He didn't share it with them, but he was using it to compare against. And he was very happy because he was like, I was the only one who told him the truth, which is you're probably going to get sued. You did something really, really wrong. You effed up. Like, get ready. So I said, team, we have to write every communication, even if it's to a client, even if it's internal, as if it was going to the other side, if it was going to be published, right? Just little things like if you're going fast, so you're trying to answer the emails, but not even thinking, oh my gosh, the audience could be bigger, right? My partner Laura says you have to pretend that every single email you write could be published in the newspaper, which is great because it stops me from firing off missives. Warranted, but still stops me from firing off missives.
Absolutely.
Yeah. I used to work in economic consulting doing litigation support, and we were taught that every email, every piece of communication, it might, worst case scenario, be either produced or published on a newspaper.
That's right.
Yeah.
There you go.
So law firm models are under a lot of pressure right now. Talent competition, new technologies like AI, for instance, globalization, alternative legal services. How are you and your team at Harper Meyer adapting to those shifts, especially in your specialty of art and entertainment law?
So I'm probably more sheltered than the rest of the other practice groups because, as I mentioned, at the end of the day, all of the technologies that are rolling out and all of the abilities that AI appear to be rolling out are truly wonderful and truly taking over some other practice areas by storm faster than mine. So, for example, I would submit to you that corporate, oh, right? Like the ability of those programs to create the most amazing contracts you've ever seen, or do a due diligence that it would take a team a week to do, and they can do it in an hour. Those things are truly, truly taking over. Our firm meets on a monthly basis to review our AI policy, our AI usage, the latest Florida bar and American bar recommendations, and to discuss like cases off the street, right? Things that we've heard of, what's happening over here, what's happening over there, because it's a big concern for all the firms. One of the partners here the other day made a comment. I won't hold him to it, but he thinks that because of AI and because of the way that the technological revolution, if you will, that we're experiencing, he thinks we might have hired our last associate. We might not actually need any more associates in corporate for the upcoming moment. And I that stuck with me because I was like, what do you mean you don't need another associate? Of course we're going to need an associate. But it's going to be really interesting. My partner Laura always says the top 10% find a job. What about everybody else? I don't know that there will be space for everybody else the way there has been traditionally. There'll be other things, there'll be other spaces, with everything, things that move and evolve and whatnot. But we in our office find that every single practice group is using AI. Every single practice group is using associates who are using it significantly. It's under heavy review. It's under heavy analysis. The practice of law is changing quite quickly. What will it look like in 5 years, 10 years, 15 years? I don't know. Because like I said, the courts are so slow. In my world, the courts and tribunals are just so far behind. I mean, remember COVID? The Supreme Court actually let a phone call hearing. Do you remember that? They actually allowed phones.
Yeah.
Phones.
The phones and all that, yeah.
Yeah, a phone. Like that's how far behind, that those two spaces are. So I don't know. I don't know what forces are going. I know they're going to come, some for the better, and what that means for the people behind me. Gosh, I really don't know.
Yeah.
I mean, if you just suddenly have a magic wand and with your experience observing different legal practices in the law, what would be like one big question or segment, or if you have a magic wand that you can make it more efficient or optimize or the entire system, either the entire system or your specific niche.
Ooh. If I had a magic wand, I would undo the advent of emails. I mean, that's been to me, that was it. That was the turning point of technology that made us as a global society become 24-hour, 7-day a week, always reachable. And there has been the biggest problem with that. While it has been amazing because it expanded people's practice and it expanded opportunity to do more work, it also destroyed any semblance of privacy and boundaries and work-life balance. And I tell every law school that I get invited to lecture at, where they're always like, what do you recommend for work-life balance? And I'm like, no. In law, there is no such thing as work-life balance. In law, I can't speak for other professions. There is such a thing as navigating the time. If you have an opportunity to go home early, go home early. If you have to stay late, you have to stay late. You balance your needs and your jobs and your life and your things. You balance those, but you do not have a work-life balance. You do not have we were hiring associates 2 years ago, and this one guy was he was really great, and he was on the top list of the candidates that we're super looking for. But he expressed to us with all candor, which I appreciated, that he had a young baby at home and his wife was at home, and that he had promised them that he would be home for dinner every day by 6. And I said to them, I love that for you. I really think that that's special, and that's like truly awesome. Why would you ever commit to something like that? That's like the biggest, like, you are creating the biggest letdown in the whole great big world. Like, are you nuts? Are you nuts? How are you going to, how's that real? How's that even real? Life has so many ways, job, work, life has so many ways of making that completely untenable. So I think it's disingenuous. I think you say, I promise that I'm going to come home every night unless I'm away for travel. But like, if I can come home early, I'll come home early. If I don't have to work on the weekends, I won't work on the weekends. If I can come in late, I'll come in late. If I can take a day off, I'll take a day off. But you know, I also had a young associate here too. He was so frustrated because he had to give up his Orange Theory membership because he couldn't make the 7 p.m. boxing class like every night. And I was just like, I'm going to throw up in my mouth. And like, this is not that. This is not that. I said to him, get a gym membership, but don't get like a constant, because you cannot commit. You can't even at work. I can't promise people that I'm available every day at 9 a.m. I am not. I might be in court. I might be asleep. I don't know. I'm not asleep, but you know what I mean? Like I can't commit. So to me, the email has really changed that, because it's always in your inbox. Even if you did decide, I'm going to take Friday off and I'm going to dedicate it to, make it a non-work day, and I'm going to dedicate it to other things that I have. Sure. But the tax you pay when you open up that email, and there are a bajillion messages. Also, by the way, fun fact, my husband says, never put out of office up emails. And I said, why wouldn't you put an out of office up? He goes, he says in his experience, when he puts an out of office email up, it's code for call my cell. Yeah. And he gets calls that say, hey, I know you're not at work today. Quick question. Bro, not at work. Not at work. So email kind of invited that invasion into our private lives that I have found very challenging for all professionals, and especially the law that is so demanding already of your time to begin with, that it has become, and it is for all professionals, from baby lawyers starting day one to folks that have been doing it for 20, 30 years, it is really hard to find time, because it's constantly competing. It is constantly competing, because you pay a tax if you're not at work, and you pay a tax if you're not at home, right? Like you're constantly, there's that line, the devil wears Prada. We quote the original one here in the office all the time. In fact, my partner made me, do you guys want to see it? A huge poster board quote.
Absolutely.
We have to rehang it, but it's all like the famous quotes. And I know it's mirrored, so it's backwards, but the way Miranda Priestley always goes, that's all. And the way she wants to say, everybody wants to be us. And no, that wasn't a question. And you have no sense of style or fashion. Florals for spring, groundbreaking. Am I reaching for the stars here? Not really. Please bore someone else with your questions. The details of your incompetence do not interest me. By all means, move at a glacial pace. You know how much that thrills me. And my favorite, is there some reason my coffee isn't here? Has she died or something? But there is a scene in that movie where the protagonist's complaining that her boyfriend's about to break up with her and her life is all going to hell. And the guy, Stanley Tucci's character, says, well, that's how you know you're ready for a promotion. And it feels like if you try to focus on your home life, your work suffers. If you're killing it at work, your home is about to collapse, right? Like it is so, and that is, to me, if I could wave that magic wand, going back to your original question, I would have undone that technology in the first instance, because it has really made technology now this pervasive invader of our lives. So much so that now look at us now, like we have to think about AI in all of these like ways that we don't even know we should be thinking about it, because we've been invaded. That would be what I would have taken away. But I don't know if you meant that in a more legal context. So I totally went somewhere.
Yeah. No,
crazy.
it's great. Yeah, it's really our final open-ended because everybody has their own take on it was great.
Yes. Clarissa, this has been a masterclass in how art and law intertwine. Thank you for sharing your insight and experience. I really appreciate your time and openness.
Thank you guys so much. Stay warm, stay bundled, come down to Miami anytime and enjoy the swaying palm trees. And good luck to both of you. We'll be in touch, I'm sure.
Absolutely. Thank you.